I declare open this first hearing of the Senate Economics Legislation Committee into Tax Laws Amendment Public Benefit Test Bill 2010. I'm chairing this meeting in the absence of the Chair, who is Senator Annette Hurley, who for personal reasons to do with her family cannot be here today, and I'm the Chair of the other committee, which comes under the Economics heading, the Economics References Committee. So by default I'm chairing this committee today of the Legislation Committee. The bill was referred to the Senate Economics Legislation Committee for inquiry on the 13th of May 2010. The committee is due to report by the 31st of August 2010. I'll just set out a few ground rules to facilitate the good operation of what we're trying to do here today. This is a public hearing and members of the audience are most welcome to observe the proceedings. However, the audience is not actually a part of the proceedings, so members of the audience do not have any right to speak, to interrupt or to contribute while the committee is hearing from witnesses giving evidence. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a Senate committee. I also emphasise that the terms of reference of this inquiry are limited to the examination of provisions of Tax Laws Amendment Public Benefit Test Bill 2010. The committee acknowledges that there has been public commentary concerning particular organisations. However, the operations of individual organisations is not within the terms of reference of this committee, and the committee does not have the authority to deliberate on such matters. They are not relevant to the bill. I ask all members of the committee and witnesses to ensure that questions and comments are relevant to the terms of reference of the inquiry. A copy of this bill is available from the Secretariat if you require guidance in this regard. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken. Excuse me, I've got a throat infection. And the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, be made at any other time. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard record proceedings. There's one other matter I'd like to raise or mention before we hear from the first witness, Dr. Stephen Mutch, and that is that the Church of Scientology has written to the Secretary of the Committee requesting a private meeting today before the committee proceedings begin. The committee has declined to have any such meeting because the meeting was to discuss matters to do with the legitimacy of this hearing and the matters that might be raised before it. I wish to state and put on record that this hearing has been ordered by the Senate, is legally constituted and is in effect a committee of the Parliament of Australia inquiring into a piece of legislation. It is no different to any other Senate committee conducting an inquiry into legislation, and only evidence given during the course of the proceedings will be considered by the committee. And with that, I'd like to welcome to the committee Dr. Stephen Mutch, a former member of the House of Representatives, who I'm sure knows all about committee procedure. So Dr. Mutch, would you like to make an opening statement?
Thank you, Mr. Chairman. Well, first, my name is Stephen Bruce Mutch, and I'm appearing here in a private capacity. I would also like to tender to the committee a copy of I've actually had them transferred because of the electronic age at less expense than a bound copy. I've had my PhD thesis of 2004 entitled Cults, Religion and Public Policy transferred to a disc. It's a read-only disc, but I know that senators are well equipped electronically, and hopefully that might be of some use or interest to you or your staffs. And secondly, I'd like to table with you also an article I wrote which might not seem instantly related to this inquiry, but it's entitled Cultism, Terrorism and Homeland Security. But in that article I talk about the role of cult watch groups in the gathering of information that might be of security use to the government. So within that article, I think there's information that might be of relevance to this committee. So I'd like to table that, and there's a copy of the actual journal in which it appeared. Thank you. Well, today, I think that this inquiry is a timely investigation into what I would probably loosely call a loophole in our taxation system. It deals with an arcane area of tax law, applying a medieval presumption which in its country of origin has been superseded for a number of good public policy reasons. The inquiry does cross a number of fields of scholarship and is seen to be complex, indeed controversial. It's also seen to be complicated and politically difficult. I don't think the truth is quite so daunting. I've been invited to give evidence today because of my academic research. When I left Parliament, I thought I'd go back and do some more work at university, which I didn't do well enough the first time around. I spent too much time with the young Liberals. But I went back to university and wrote a grad dip arts, which was entitled From Cult to Religion. And I've also already tabled that in the sense that I've put that as an annexure to my submission. So I've given that up as a bonus to the committee members. The PhD which flowed from that dissertation is a much more nuanced analysis of this area, and I go into far greater depth and have changed a few of my views, not very much, but the PhD is the document that I'd like you to look at in your busy lives. But the research that I undertook at university flowed from my own activities as a parliamentarian, both at the state level, where I was a member of the New South Wales Legislative Council, and then federal from 1988 to 1998. Now, one of the reasons I've been asked, I presume, is that at the moment I'm an honorary associate in the Department of Modern History, Politics and International Relations at Macquarie University, and I teach, among other things, courses on Australian governments and public policy and Australian foreign policy. I also conduct there a colloquium for the Global Leadership Program at Macquarie on religion, secularism and the state. And when I have time to do any research from all the teaching that I do, I like to look at this area of the interrelationship between new religious movements, people sometimes call some groups cults, sects, and indeed mainstream religions and the state. My field of research is public policy, in particular the interaction, as I said, between cults, sects, new religious movements, established religions and the state. I've published a number of articles in this field, and my doctoral dissertation anticipates this inquiry in that it proposes my ideas for a way forward. In public policy terms, we call this a bottom drawer solution. I think the Americans call it a trash can solution, but in that it has been quietly gathering dust, awaiting an opportunity such as this, really. I'm pleased to be the first cab off the rank, and I note that the Australian Taxation Office seems to be the other bookend, but really their submission is of the utmost importance, and we need to focus very much upon their submission. I think the Treasury submission pretty much confirms the concerns I raised in my own submission about the inadequacies of the present system. I think, firstly, as well, it puts to bed a major objection to the proposed bill, and at the same time it raises the need for administrative and policy support to bring the bill into effect.